यांचे आगमन होत आहे. वेलकम सर. Good evening, one and all. I, Advocate Baliram Bhausaheb Shinde, Chairman of Library Committee Advocate Association of Bombay High Court Bench at Aurangabad. I am very happy to welcome you all for 4th lecture of lecture series organized by Advocate Association of Bombay High Court Bench at Aurangabad. We are very delighted to have with us Senior Advocate R.N.Dhorde sir as a speaker of today's lecture. As a token of appreciation and gratitude, I now request Advocate Avinash Borulkar sir, President of our Bar Association, to felicitate Senior Counsel Advocate R.N.Dhorde sir. Thank you, sir. Before proceeding with the program, I now call upon Mr. Avinash Borulkar sir to give presidential address.
व्यासपीठावरील श्रेष्ठ आणि ज्येष्ठ वकील धोडे साहेब, माझ्या कमिटीतील सहकारी उपस्थित सिनियर वकील आणि सिनियर काउन्सिल तसेच वकील बंधू भगिनींनो, आज खरं तर मी लिहून वाचणार नव्हतो, भाषण उत्स्फूर्त बोलणार होतो, पण धोडे साहेब असल्यामुळे मी जरा ती संयम ठेवला आणि लिहून आणलं आणि ते भाषण करणार आहे. तर आज आपण सगळे धोडे साहेबांचं आर्ट ऑफ ॲडव्होकसी या विषयावर लेक्चर ऐकण्यासाठी जमलेलो आहोत. तसं बघायला गेलं तर धोडे साहेबांबद्दल काय सांगायचं, कारण धोडे साहेबांना आपण दररोज कोर्टामध्ये ऐकतो बघतो. त्यांच्या कोर्टामधलं जे सिनियर काउन्सिल म्हणून जे काय वावरणं आहे, कोर्टासमोर ॲड्रेस करणं आहे, हे म्हणजे एक त्या सिनियर काउन्सिल या पदाला शोभणारं असं आहे. त्यामुळे त्यांनी कधी त्यांची मर्यादा ओलांडली नाही. तसेच कोर्टामध्ये नेहमी डेकोरम छान मेंटेन ठेवलेलं आहे. धोडे साहेबांचं भाषेवर असणारं प्रभुत्व, कायद्यावरच्या ज्ञानाची पकड ही मोठी बाब आहे आणि याचमुळे सरांना सिनियर काउन्सिल हा बहुमान मिळालेला आहे. मी जेव्हा 1996-97 साली हा बार जॉईन केला, तेव्हा या खंडपीठामध्ये जरा हेवी स्टेक किंवा ज्याला कॉन्टेस्टिंग मॅटर असले, सिव्हिल असो क्रिमिनल असो, त्यावेळेस मुंबईहून सिनियर काउन्सिल आणले जायचे आणि त्यांचं आर्ग्युमेंट व्हायचं. पण आपल्या इथे धोडे साहेब सिनियर काउन्सिल झाले आणि त्यांच्याबरोबर अजून आपल्या इथले दोघं तिघे जेव्हा सिनियर काउन्सिल झाले, तेव्हापासून ही प्रथा आपल्या खंडपीठातली बंद पडली. धोडे साहेब सिनियर काउन्सिल झाले, त्यावेळेचा माझा एक स्वतःचा अनुभव मी तुम्हाला सांगतो की माझं एक मॅटर होतं, शिक्षक होता, टर्मिनेशनची ऑर्डर होती, संस्था चालक जरा बलाढ्य असल्यामुळे त्याने रिपिटिशन केलं वगैरे होतं. तर त्यामध्ये मी सरांना एंगेज केलेलं होतं. सरांना माझ्या क्लायंटची परिस्थितीची जाणीव करून दिली आणि माझी परिस्थिती सरांना माहिती होती. त्यामुळे सरांनी मला एवढी फीस द्या तेवढी फीस द्या असं कधीच हट्ट केलं नाही आणि मला कधीच त्यांनी मागणी केली नाही. आणि अशा प्रकारचा अनुभव हा बऱ्याच वकिलांना आलेला आहे, हे मी छातीटोकपणे सांगू शकतो. मी जेव्हा माझी वकिलीची सुरुवात रघुवंशी साहेबांकडे, ॲडव्होकेट R.B. रघुवंशी यांच्याकडे केली, त्या काळी 96-97 साली आपल्या खंडपीठामध्ये ज्युनियरना रागवणारे फक्त 2च सिनियर होते, त्यामधले रघुवंशी आणि धोडे साहेब. साहेब माफ करा, पण हे आपले त्यामुळे पण साहेबांचा जो रागवण्याचा जो उद्देश होता, जो हेतू होता, तो ह्युमिलिएट करणं किंवा कमी लेखणं हा नव्हता. तर त्यामधून त्यांना एक चांगला वकील, उद्याचा उत्कृष्ट वकील बनवायचा, ही त्याच्या मागची हेतू आणि प्रेरणा होती. आणि त्याच प्रेरणेने जर आपण साहेबांचे जर ज्युनियर बघितले तर सूर्यवंशी साहेब, जे जस्टिस सूर्यवंशी साहेब, त्याच्यानंतर अडसुरे सर, विठ्ठल दिघे सर, आणि अलीकडच्या काळातले म्हटलं तर नितीन गवारीजी आहेत, अनिल गायकवाड आहेत, आणि विक्रम कदम, दिघे, राहुल तांबे, नावं घ्यायला गेले तर खूप आहेत. पण हे जे काय आपले ज्युनियर सरांनी जे काय तयार केले, ह्यांचं आपण काम या कोर्टामध्ये बघतो, ते उत्कृष्टपणे वकिली करतायत. ह्याचं श्रेय सगळं धोरडे साहेबांनाच खरं जातं. सर तुम्ही म्हणजे आपल्या खंडपीठाचे एक उत्तुंग असं व्यक्तिमत्व आहात आणि आमच्या वकील संघ खंडपीठाचं एक तुम्ही ॲसेट आहात. एवढे माझा शब्द बोलून मी इथे थांबतो. जय हिंद, जय महाराष्ट्र.
Thank you, sir. Now I have great pleasure to give brief introduction of our today's speaker, Senior Advocate R.N.Dhorde, sir. Sir born in 1952. Sir has completed BA Economic from Bombay University in 1972. Sir has completed LLB from Government Law College, Bombay University in 1975. After completion of law degree in 1975, Sir has enrolled as an advocate with Bar Council of Maharashtra and Goa. And Sir started practice in Bombay High Court in 1975. And Sir has joined Chamber of Senior Advocate Honorable Shri A.V. Sawant, who was subsequently appointed as the Chief Justice of Kerala High Court. In 1977, Sir has completed LLM from Bombay University. And in the year 1988, Sir shifted in Aurangabad and started practice in High Court bench at Aurangabad. Sir has conducted various types of civil, criminal, as well as constitutional matters. In 1994, Sir elected as a President of Advocate Association of Bombay High Court bench at Aurangabad. Now I would like to request today's speaker, Senior Advocate R.N.Dhorde, sir, to share his views on the topic of art of advocacy. Please, sir.
The President of today's function, Shri Borulkar, Secretary Shri Gore, the Chairman of the Library Committee Shri Shinde, Vice President Shri Kaude, Shirkhane Madam Vice President, my colleague Senior Advocate Mr. Sapkal, and my friends at the bar. Now, art of advocacy is not a new subject to you because all of you have been arguing in the court differently. But then what happens is what we faced in our young days, particularly those students who are coming from a vernacular medium, walked, talked, he didn't do it, hadn't done, they was, all this happened with us. It is not that it is happening with, fortunately most of you are more familiar with the English language than what we were at that time. Now, art of advocacy is what? That advocate, anybody, any common man can be an advocate. Advocate of women's liberty, advocate of scheduled caste, scheduled tribe cause, advocate of the right to liberty and freedom of expression. So, anybody who is an advocate is a person who represents a particular cause. Now, in courts, advocate is a person only who has been authorized to represent his client or his cause according to the 1961 Act, that is Advocates Act 1961. Now that Act says the person who has been authorized by the Bar Council, who is enrolled with the Bar Council of the concerned state of All India or All India Bar Council is entitled and eligible to be represented in the court. Now you know that it is not necessary that one should be an advocate. A client can himself appear, not necessary that you should engage an advocate. But why an art of an advocacy is more important? Now I will tell you some of the reasons that an advocate who has to appear in the court, he knows many things, but he is not able to speak in the court. I will tell you my own experience. When I was at Bombay and I joined the bar, the first matter I appeared was civil application for bringing LRs on record. And I had a tension, what is to say, and if I am not able to say, then what will happen? And when the matter was called out, it happened the same thing. I went before the court. He said, what is this civil application? How many days delay? 6 years. What were you doing for 6 years? There was a lot of respect for him, and therefore you have to be little limited in the court speaking. So I said, sir, no, you tell me what he was doing. Then I was not able to explain him properly. 6 years delay, second appeal dismissed, delay not condoned. And then with a small face I went out of the court, all looking everywhere. They are all, whether they are laughing at me or not, and all this has happened. Now, I was not able to tell the court what was my case is only because I did not know my advocacy. That means what is the advocacy? That I did not know what I have to tell to the court. Now why this happens? Now if you know in a public speaking classes, this is one stage which is called as a stage fright. If you are asked to somebody, suppose tomorrow Mr. Borulkar is asked to somebody in a public speech, held for an MP, for some MP, either he himself is contesting or he is canvassing somebody else, and the large crowd is there. Now we argue here in the court, but you go and appear there on the stage and make a speech, and you will find there you don't know what to say. So this happens. So what went wrong with me on the first appearance of my case in the court was, in the High Court, was that was a stage fright. That when you go on the stage, you forget what you have to say, and then you say what Mr. Borulkar will look here from there, who will say, who is watching me, whether I am going wrong, and all these things come in your mind, and then you are not able to express yourself. So the first thing you have to take out is that you have to remove your stage fright. Now this is a part of a public speaking, so either you develop it yourself or you have to go and join some public speaking classes. Now that stage fright can be removed during the college days, or now there are good courses, this moot court and all these competitions are being held. So therefore the young batch of students who are coming, or young lawyers who are coming, they are well equipped with this. Fortunately, they are also well equipped with the language. So the first thing you have to cross in a lawyer's profession is to remove the stage fright. Must know what you have to say, and you should be able to say so. Otherwise, like me, second civil application for LRs dismissed for condonation of delay, appeal dismissed, small face, and go out. Now I will tell you, I followed what was it. No, I was at that time already an LLM. So I had an opportunity to go and join a lecturer, because the lecturers that time we were paying 400 rupees. So 2 rupees deducted as a professional tax, 390 you used to get. So if you are a lecturer, part-time lecturer in a college, practicing lawyers. So I told my senior, sir, if I can be adjusted at some college, because I had small 5 or 6 months, because you must have 3 years practice, and I had some sort of running. So my senior took me to the same judge in the chamber, saying, sir, he is my junior and he is appearing tomorrow for interview of a lecturer. Now you tell me what is a contract. Now you just imagine, when you were sitting there, I was afraid. When you were sitting in front of me, what would be my position? So I fumbled. So he says, Mr. Sawan, look at him. He is not able to say properly. And look at him, then student will hoot him out from the class if he is not able to teach them. So I came out of the chamber with my senior. Then my senior told him, look here, contract means a determination of civil right between the two parties, or more than two parties is a civil contract. That is what you should have told him in contract. Sir, but he was looking at me, so what happened? So what I was trying to tell you was that when he told me, then I didn't go for an interview in that college, and I left over like that. But what I did was that night I thought myself, this is the second time it is happening. First in second appeal dismissed. Today I am rejected without going for an interview in the introductory introduction itself with a person who is likely to interview me. So that night I was determined with myself, saying that I will not be afraid of saying anything except bad words in the court. Say anything, go express, Punjab Express, email, Calcutta mail, whatever it may be, start to finish. And then from that day onwards I never looked back. Then I went and joined a law college National Law College at Bandra. There I used to take lectures, and the subject given to me was Hindu law. So initially I had, because that Bandra area was all convent educated students, so they used to ask me very well, sir, what is some English word they used to ask me. And then I used to say, I don't know what is it. So I used to tell you tomorrow. So what I did was, then I developed an idea. I started teaching them in Hindu law the Hindu Divorce Act, Hindu Marriage and Divorce Act. So then I used to all teach them evidence under the garb of Hindu law, how the marriage went wrong, how the evidence was collected, where the camera was fitted, where he got the evidence, and then they used to look like this on me. Complete 50 minutes, pin drop silence in the classroom. Then slowly, I started making notes like this now, preparing as we go in the court, and then started delivering lecture. It became, they started liking me, then slowly that second part came. Uncodified Hindu law, that partition, that Bengal school, Bombay school, these schools, they got so bored. I told them very frankly, if you want to sit in the class, please sit in the class or go away. But what I am trying to tell you is this, that when you address the court initially itself, you must know what you have to address, you must know where to begin, and you must know where to end. Otherwise, what happened was, and what happens in the court is generally, even it has happened with me, I am not saying that man is perfect. Second appeal, a matter was being argued, and the court called upon the lawyer who is arguing, saying that yes, what is the question of law in this matter that is framed, or what you want to argue? So he said there was one Dhundiba. Dhundiba had two wives. First wife, second wife. Then that wife had two sons. First wife. He had 3 sons and 1 daughter. The court was asking you a question, what is the question of law? Simple was whether under section 6 of the Hindu Succession Act and read with section 14 of the Hindu Succession Act, whether that Dhundabai has become an absolute owner of the property. That's all. But he started with Dhundiba and ended with somebody else. The court said it's all right, anything else? Yet the court heard him for 5, 10, 15, 20 minutes and that's closed for order dismissed. So this is what happens. Sometimes you have to argue, formulate the point. That is the part of an advocacy where before you go to the court, you must know what you are going to argue in the court. So that is another part of an argument, that when you go and argue a matter like second appeal in the court, you must know what is the substantial question of law. At the same time, you must also know that what is the latest position of a substantial question of law decided by the Supreme Court. Now in matter, what happened is that a matter was argued in our court, matter was heard by the learned judge, and he said this was a question of law framed, but now I framed this question of law, I heard the arguments, and he delivered a judgment. Matter went to the apex court, and the other side said, sir, this was never, though this was argued, but we were never told that this was a substantial question of law and we have to answer that. Set aside, matter remanded back. So what I am trying to tell you is this, that when you argue the matter, you have to take the latest judgments of the Supreme Court on the point of the substantial question of law to be argued, because you must make aware the other side what you are going to argue. You can formulate your own question of law out of which you can give it to the note to the other side and you argue it. The learned judge may, honorable judge may take 2 question of law out of it, or he say none of these arise, appeal dismissed, whatever it may be. But the formality of giving notice to the other side and then arguing the matter on those question of law along with the case laws is complete, so that you don't have to come back again with saying same thing. Now the next important aspect is, in order to become a good advocate, first thing is join the chamber. Otherwise today, in the age of an YouTube university, everybody is senior. You don't require any senior to tell what you are going to do it, or I can say that they are more smarter than senior, because they are updated in technology. They understand the technology. But that doesn't help you. If you join the seniors chamber, what you have to do is the first thing is to go to the office earliest possible. Earliest possible doesn't mean that 5 o'clock in the morning. You should go 9 o'clock, 8:30, 9 o'clock. Take the board, see what are the matters on board, see which matter has been assigned or is it assigned to somebody. If there are orders matters, if you are a new beginner, you can see that which matters you can take up, or if it is given to you, suppose your senior comes in, he says take this civil application which for respondent or for stay or for vacating stay or whatever it may be. Study that matter and go to the court so that at least you will not fumble like me in the court. Second most important thing is mentioning. Now when you go to the court, at least at our time we used to literally mug it up and vomit it out. Means what? May I with your lordship's kind permission mention a writ petition for an admission tomorrow because urgency is this, that the board is likely to be taken over where the order has been passed, therefore kindly grant this matter. Now this long mentioning, nowadays the judges don't have time. Yes, take order matter one day, outright, any urgency mention. Now while those who remain for mentioning, they have to also learn one or shortest possible mentioning to the court. Sir, I am likely to lose possession day after tomorrow. 6 is the last day where the stay is granted. If your lordship can grant me tomorrow, please grant me. Otherwise, first matter on board on 6th or whatever it may be. So mentioning is also an art. In fact, in our High Court now, they have stopped the senior advocates permitting to the mentioning. But in Supreme Court, even the senior advocates mention the matter and get it fixed or whatever it may be for admission or otherwise. Now don't ask me the rates of those advocates who are mentioning the matter. Now another important aspect is, I will just give you the example which has happened with me. My senior became an advocate general and suddenly myself, Mr. Hoon and Mr. Rajesh Ketkar, we three were only in the chamber. So any matter, the board used to come late at night. That time it was a cyclo-style board. We never used to get online and all this. So you forget earlier day, morning you will get the board when you come to the office. So one day what happened, I had two matters to be mentioned. TRA I mentioned it, I wanted to mention it. So I was second in queue, first man mentioned. The moment, before first man could mention, the judge was likely to sit here like this. The other day I told to the law student, he was about to take a seat like this. May I mention with your lordship permission the second civil application for stay because I am likely to lose this. He put his glasses here, he put his water glass here, he says dismissed, rejected. So I was surprised. So I coolly went out, so what to do? Somebody reported this to my senior saying that he says that is not the way that you should mention. You should allow the judge to sit on his chair, put his glasses at one place, his water glass at another place. When he is composed, then you mention the matter. Otherwise you are not allowing him to mention. He doesn't know what date, which matters are there. And you are saying, may I with your lordship permission mention a civil application? What is this going on? So then next day I went again. First of all I tendered the apology. Then he said, no, nothing. You don't know how to mention. You just come to the court and wanted to run to other court because you was also a lawyer, he knew it. And just then said, I tender my apology. My client will suffer. Then with great difficulty he said, no. Then I was about to leave. He said, all right, 2 days after granted. So this is what happens when you are in the queue mentioning the matter. Many times. Now don't take it otherwise. Judges here are very calm and quiet. I don't want to use any other word. They treat you very nicely. But then, if you go to Bombay, perhaps he was such a fiery judge, he will ask you one question. Before he could end his first question, he will have his second question in his mind. He will fire that also. So you don't know whether to answer first question or second question. And he was, very outspoken in the court. He will tell the lawyer straight away, if you are not able to put the point and you are arguing here and there, you will say, Mr. So-and-so, what is this you are arguing? You better open a barber shop at Vitti Station. Straight. Now one day I was arguing a matter in his court and my English, I was from vernacular medium. So I was saying, sir, this my criminal matter bail application. So I told the court, I started arguing and I said, sir, my client is dumb and deaf. He said, what? I said, deaf. It is deaf, dumb and deaf, one who is not able to hear it. He said, what English you are speaking? I don't understand the language which you speak, and what the language you speak is not English. Then she told me, don't say deaf, you say deaf. Then I said, sir, sorry. So, what I am trying to communicate with you is that you must have a mastery over your language. I am not saying that English is our language and you have an Elizabethan English, thine and mine, thine and yours, know thy judge and all this, not necessarily. But you should have good mastery over the English. Many time when we speak in the court, my lord, no, please pronounce properly. I am not saying that. I also come from the same language. In fact, you are better. I come from a Jilla Parishad school. But there is always scope for improvement. Then, my lord, he didn't do it. No, he didn't do it. When you dictate, you can say didn't do it. But the pronunciation is he didn't do it. Then, many times the judge is asking you a question. Mister, is this a point in this matter? Before the judge could complete his question, we will throw an answer. You know, the day before yesterday reported on YouTube, the Chief Justice of Gujarat High Court was asking a question to a lawyer. They had some other grievances. The President of Bar was arguing. And before she could complete the question, she said, my lord, I have understood your question, this is my answer, and a quarrel started. That is not the way a lawyer should ask. Many times, the court is with you. Even if it is against you, you have no, they are not biased against anybody. But sometimes lawyers feel that I am not being able to argue. The question which the court asks, you have to listen it to the very carefully. One, many times it so happens that they are dealing with so many matters. A matter which you are arguing, they say, these are all matters clubbed together on a particular day. So you don't have to waste your energy. Notice, stay, go home. If it is only notice in other matters, you are also bound to get, you can argue for interim leave. But the second important aspect for becoming a good lawyer, a good advocate, is you must hear the court's queries properly and then answer in whatever manner, because then you will be able to answer it properly. Now it used to happen with me also, that before the ball takes the place on the pitch, you are ready with the batting. But here you can't do it, because that batsman also wait till the ball comes to him. He doesn't go further. So many times those who go further are LBW or their wicket is taken. That is what happened with us, that when we argue the matter, we many times don't allow the judges to make a queries. Or some lawyers, many on occasion, rather they don't like, what is this being asked to us? I want to say this and the court is asking me something. But perhaps you have to answer the question, because you have no choice but to answer the question. So, second most important thing is listen the question, what the court is making the query, and answer the question. Now, the another important aspect is that nowadays you know that the judges are being appointed very slowly, or they are not at all being appointed. Now the workload is increasing. The citizens are becoming aware of their rights. They are also being aware that if you can go to the Honorable High Court, you can get directly a relief in some matters. They know, some of them know the case law also. Since the load of work is increasing, many times you have to be careful when you file a petition, whether it is maintainable or whether it is not maintainable. Otherwise, what happens as a lawyer, you tell many things to the lawyer, it is very good case, we will go. Day before yesterday, my friend so and so argued this matter and he got this. That matter is tenancy matter. Some other point we tell the client, and when we go to the court, they say, no, how you have come here? There is appeal maintainable to the collector or to the MRT or elsewhere. You should have gone there in view of the alternate remedy. This is not permissible and you have to withdraw the matter. Then you know what answer the client will ask you. So many times it so happens, so you have to be very, very frank with your client, saying that this is what it is, but if you want, I will file a petition. Then there is no problem. But if you say that, no, I will get the order, then you will get the order from client. So it happens many times, quarrel take place outside in the presence of the bar. So as a lawyer, we can avoid that. It is my suggestion to you. Next thing is that once you have a mastery over the language, in order to do that, what you have to do is, now nobody reads the newspaper because you get all newspaper all news on the YouTube or LC. But my suggestion to you is, Times of India is one such newspaper which uses a very apt and accurate and very simple English language. It doesn't go into the all niceties of words and gobbling the words here and there. Times of India is, according to me, is a best magazine, a best daily newspaper where you can read it, you can understand it. And those who have more time, you please read the editorial. And also above the editorial there are 3-line thought of the day. So that thought of the day, if you read it, you can always use that sometime if you mug it up while arguing the matter. Many times one day one lawyer was arguing the matter and some newspaper, it was about some newspaper. So he said men are wise not in proportion to their experiences but their capacity for the experience. Means what? What you learn from your experience is more important, not that how long. It is not that a lawyer, how old he is and how long practice he is having. Question is what he has learned from the practice. If you argue a tenancy matter, what perfection you have got in the practice, what you have learned from your practice. It is not that you have just practiced for 20, 30 or 40 years. So therefore men are wise in proportionate not to their experiences but their capacity for the experience. So when you argue the matter, it is not just because you argued the matter, but what you have learned from that matter, where the pitfalls, what you should have argued and what you should not have argued, not the suppression of fact. Research to be done. So you should be, that is what happens if you read the newspaper like Times of India where there is a thought of the day, above the editorial in that. Then there is that jugular vein, if you have more time please read that, but that is not very important. Then what happens is in second appeal, normally what we do is 2 court judgment, read them, fire the second appeal. I was also doing at some point of time. And then, but what I have done was that I will draft first that, but I will not finalize the draft. I will first thing in second appeal is to get the paper book of an appellate court. You have a plaint, written statement, issues and evidence. Now many a times it so happens that the issues are argued or wrong issues are framed. The matter is about the succession of the property under Hindu law and the point decided is something else, whether under section 14 this was done. So when you have to read when you file an second appeal because you are almost trying to find out something in a heap of papers. In that second appeal you are trying to find out a question of, and that is also a substantial question of law. But I am sure that at least for the purposes of admission of a second appeal, if you read the plain written statement, issues and the evidence of the trial court, you will certainly able to get something prima facie to argue before the court as in a second appeal, which is a substantial question of law. Now many times what happens is while we argue the matter, we forget a judgment reported in 1978 Supreme Court. A will was there. Question was how much was given to which son, how much was given to the grandson. So what that will has expressed in expressly given to the persons who are entitled to. Supreme Court said a will which has to be read and it is to be construed. A construction of a document is a substantial question of law. Now this has happened about will. What about agreement to sell? Same thing, because it's a document which you have to read. And the construction of an agreement to sell, whether the possession was given or not, whether the possession would be given, whether he was ready and willing, whether this was a monetary transaction and security, you have to, in order to plead your case and become a good advocate, you have to be ready with this. Unless you read this, you will not be able to present in the court. Many times what happens is, you have to go with the judge also. Suppose you frame 2 questions of law. He says, no, there is one more question of law. I am grateful to your lordship. But at least 2 questions of law or 1 question of law to be framed, you have to read this. You should be ready with the judgments. That is another important aspect which you say. Now most of the cases, important aspect is any property, first be ready with genealogy of that person. Whoever is there, because you know the suit is filed in 80. Now the second appeals are being decided in 2010, 2015, 20. So many years are passed on. What happens is, unless you know the genealogy of a person, yes, who is this person, then you have to tell he is the original plaintiff was so and so, that property inherited him from so and so, the property has come to he filed a suit, he died during the pendency of these are years. So once the judge is clear in his mind as to who is fighting with him, it becomes easy for him. Otherwise you read the judgment halfway and then he says, who is this plaintiff? So it all goes again back to stage one and then again go back. So in order to put up your case as an advocate and a good advocacy, prepare the genealogy of that matter, either in property matter or anything else. Second most important aspect is while writ petitions, when you have to argue the writ petition, you yourself take instruction from the client and you have to start with the client. When you are born, suppose service matter, when you are born, when graduate, completed graduation, whatever educational qualification, when did you appear for Public Service Commission, and then when did you join, where did you join, when you became permanent. Sometimes you say, what is the necessity of this, all this nonsense? He was appointed as an... But then in that service matter, when he was appointed and we joined it, when he became permanent, then thereafter your next question is there any departmental inquiry held against you? So you know the character of a man. You have to sometimes disclose in the petition. In cooperative societies, you have to ask when it was registered, what sort of cooperative society, when last election has held, because most of the petition would be an election that hold the elections, or elections are wrongly held, or somebody is disqualified and all this. But you must know the basic kundali of your client, when it began and where it is now. So taking all these instructions, then only you will be able to perform better in the court as an advocate. Now, many times it so happens that you file, the petitioner is a society registered so and so, and you don't disclose whether it is dairy society, whether it is agriculture society or whatever it may be. And then when you go to the court will ask, what is this matter about election of what society? And then you start looking here, there, who is what it is. And then you see this does not create a good impression in the matter about a client and yourself, or at least about yourself. So my suggestion to you is this, that when you prepare a petition or any other matter or service matter, you have to have the basic knowledge of all this with the client. Otherwise you will say, why waste time in all this? Judgment is there. This is original application is there. All information is there. But that is only one court where you are coming almost like an appeal before the High Court, though you are coming in a writ petition, because the Maharashtra Administrative Tribunal is supposed to be presided over by the High Court judges, therefore it has gone to the division bench. Now, while drafting the petition, advocacy I am telling you, not about drafting. Many times we forget the writs. My colleague has already told you about drafting earlier, Mr. Sapkal, Senior Advocate. But there, issue a writ of mandamus, is there a writ of mandamus directing him to reinstate him in service. Or if you are coming against an action of the government and you don't want action to be taken, very rarely we have seen our writ, the prayers made, issue a writ of prohibition, any other writ of prohibition or any other direction in the nature of writ of prohibition, prohibiting the government from taking any action in pursuance of the so and so notice to demolish my house or dispossess me or whatever it may be. Very rarely writ of prohibition, hold and declare that, or writ of mandamus prohibiting the government from taking any action. So please, what happens is, I will tell you, don't take it otherwise. But when the judges from other courts come here, they see our drafting, then that is how they feel, and we feel hurt. Arey, what they are coming from heaven or earth. And ours is only like this. Accept us. And the next suggestion is, no judges are taken from our bar. What is this going on? And then you must take 4 or 5 judges from this and then. Now if you plead like this, if your pleadings are like this, what impression will you be creating on the judges who are coming from outside? So my suggestion in the interest of the bar, we committed a mistake, it's all right, we are trying to learn, everybody tries to learn from it. But if you have to create a good impression about the bar, about your English, about your drafting, and then advocacy, because if all these things taken together, then the advocacy will come. If you don't go with all these things, you can never do an advocacy in the court. So that is very important. Quo warranto writ, prohibition, then certiorari, and then next is what? Mandamus. Now certiorari writ, there is various misgivings among the lawyers. Even I was for some time doing that. I was under impression that the certiorari writ is even the single judge. But now the rules are very clear. If you are challenging the order of any court or tribunal, then it goes under 227. Now there is no difficulty. But under 226, if you are challenging any order of an authority or any deciding authority, any proceeding between the parties, then what they call is, actually previously they used to call it certiorari. Now certiorari writ is, the word certiorari means to certify. You are certifying the judgment of a trial court or an appellate court which is challenged before you, and the High Court will certify it that whether the judgment is right or wrong. If High Court refuses to certify, judgment will be set aside. If the High Court certifies that judgment, then the petition stands dismissed. So that writ of certiorari, now it goes only to the division bench. So please check this up. Even my suggestion to you is, before you write all these things, you have to check with what prayers we are making. Many times now here, fortunately for you, many people may not agree with me, but judges are very, very liberal and they are very lenient to the advocate. When my senior used to give me second appeal, criminal appeal, or anything before him, we never used to sleep earlier night. Because the aura of his was, he was such a brilliant judge, and the question he will put to you was so fast, just like bullet firing one after another AK-47. So, but then since the judges are very lenient to you, that doesn't mean that you cannot change your style of arguments in the court, and that will come only when you are perfect in your drafting. Then friends, thereafter is the next important aspect for the advocacy is I was arguing one matter, the petition, and then what happened was that I filed a petition, and I think I was junior hardly 3-4 years or 2 years. There was one Budhargad Kharedi Vikri Sangh from Kolhapur, and the matter was already decided. We members were not party, and the High Court decided that you should take the voters list from this date and go further. Now we were enrolled thereafter. Now that client came to me thereafter and he said, so in view of that AR 63 Supreme Court, if you are not a party to the earlier proceeding, you can still file a second petition. I have prepared it, I annexed the judgment and this. Now the court heard the matter, notices and all that, and it allowed it. Now what I did was that I did not make the earlier person who were party there to the party to this petition. And then lot of things have happened there, arguments are gone there. Actually it was my duty to make those persons as a party also, and also disclose the fact that how the matter progressed, earlier matter. Now I succeeded, court set aside the earlier judgment saying that these persons are members, they should be included in the voters list. 8 days thereafter they came back, a review of that order. And when I read that review petition, I was literally shivering in my pants. All allegation made therein that this is all suppression of facts, court is misled, and it was true also, because so what I prepared an affidavit, filed it and all that, but then I was literally, I lost my sleep also. Then I went to Mr. Adik, Ramrao Adik. Then I told him this is what happened, I committed a mistake, I was not knowing, and my client wants to engage you. So he went there. Now, sometimes it does make a difference. So he tells, sir, it happens. The court said, no, Mr. Adik, your lawyer advocate on record has committed a serious mistake. He has suppressed all this fact. Henceforward, we will keep it in mind that such lawyers like this, we will see to it that their matters are thoroughly heard. We check their pleading and everything. And this is what is happening. The whole voters list has been done this. Mr. Adik was there. My lord, we also practice all this. It happens sometime in this with a lighter mood. He took the yes somewhere else. All right. He allowed the review application, set aside that order. Point to be noted is that in order to be a good advocate, you have to see to in the brief that the facts are not suppressed. Sometimes they are difficult, but disclosing the fact would make it very important. Our friend lawyer Vijay Patil, He is here. One day what happened, he was in the court. Not with me, but I was just sitting in the court. And the court told him that whether you have lost the control of that Dudh Sangha, Dairy Sangha, something like that, and they have taken over the charge. So he said, sir, I don't know, but I will take instruction. Still the court granted him stay. Now in the afternoon, he went and mentioned to the court, sir, I was wrong in the morning, and by the time the petition could be heard, the possession is already taken over, control of the Sangh. So the court said, it's all right, he has mentioned the matter mentioned in that and all right. Then we still continue, restore the charge back to the elected body. See, he was fair enough to tell to the court that while I was here, by the time I make a statement, I was not knowing, but now I lost the possession when the matter was heard and I made a wrong statement. But still the court was fair enough to tell him that if you have taken the charge to the authorities, hand over the charge back to the petitioner, because they are in elected body and they should continue in possession. So this is what happens as an advocate if you are fair to the court. Otherwise also you already lost the possession, so keeping it back, somebody will come after some days and it will create problem. You can share this with Mr. Vijay Patil, who must be sitting here somewhere, or he has not attended. No, he will not attend because he has got the control of the Sangha. So my request to you is, don't suppress the fact from the court. Many times court says, are you in possession? So you have to be fair to the court, whatever it may be, lost, not lost, and all this. Now another important aspect is that what we do is, now there is another thing that is creeping in our profession. ठीक है, कितने टाइम वेल कितने जाना? नहीं विचारलं काय आहे का म्हणून. Now another fact that is taking place is, and I must share with you, this is worrying. English is a language to be used in high courts. English is a language to be used in district courts and in magistrates courts or civil court. Now new fad is taking place because the clients don't understand. Therefore we don't understand what the lawyer is saying. And now we are also responsible to some extent for that, because what the client doesn't know we speak and he doesn't understand English. But now that period is gone now. Everybody is educated, almost 90-80%. But because of use of a local language, what happens is that you lose sight of a good judgment from a different high courts. Fortunately for today, in the high court, as an advocate, we are arguing the matter. We argue in English. But what happens to the trial court? Ultimately, you are referring to the judgments of the high court only, so you must know English. So why this insistence that judgment must be in Marathi? Why? If the clients want, now there are various apps, it can translate the judgment in Marathi. But because client wants to know it, it can do it. But what you lose is that the next generation of lawyers which are coming up is this, which they come here also. Then you ask them to argue the matter in high court, they start fumbling. This is another thing where the lawyers, as far as if you ask me very frankly, no. You have to have in all courts the language only and only in English, because the judgments are reported in English. There are now many in this Surface Act. Very good judgments from Madras High Court. I had a good advantage of reading those judgments from Madras High Court and citing before this court, which were subsequently confirmed by the Supreme Court. Take a case, it would have been Tamil Nadu or Tamil language. What I would have got it? So that is another aspect of, as a lawyer, while we practice, we must see to it that we use only an English language, and therefore, now your language need not be an Elizabethan English. It has to be simple English which everybody understands. It is not necessary that you speak a very, English which is taught you in convent schools, and then you ask a particular word you use in a particular fashion. Not necessary. That is, it's all right. If it is there, it is good. You should appreciate it. But it is not necessary that should cause any hindrance in your language. Then another important aspect is that the grammar. Now, most of the students, you are all English educated. Your English is with a slang language. Da, di, bro, all this, what is, all right, perfectly, that is your language of your generation. But you must read Tarkhadkar, which is a grammar which teaches you how to write English and how to speak English. Otherwise, I am, we are. You are, you are. He is, she is, it is, they are. I do, we do. You do, you do. He does, she does, and it does, and they do. Now, nobody knows where does, they does, and he do. That is what happens. I am not finding fault with you. I also learn like you only. But my request to you is, please refer to an Tarkhadkar's English which teaches you a good grammar. If you suppose you have time, otherwise mobile, app, university, it goes on like this. That is another important aspect which you should have. Then another important aspect is that this is all about writing your English. Then there is another last thing. They say that know thy judge than thy matter. Know thy judge. Thy means what? THY, Elizabethan English. But it's a old saying. Know thy judge. That means thy means your. Know your judge better than your matter. So you must know the judge who is sitting, what are his views about the matter, how he communicates, whether you will be answered to this. Here, when he talks less, what you have to do. When he talks more, where you have to listen, where you have to pass. So, unless you know this, he will throw you a volley of questions and you will tell him, yes, sir, this is what it is, this is what it is, this is what. You will committing, you don't know what he is speaking and he doesn't know what you speak. And then what happens is the total communication is lost, matter goes elsewhere. That is why know your judge than thy your matter. And therefore, you must know your judge. Now, many times while mentioning the matter, I think you, all of you must have learned by this time to read the temperature of the court. That today, what is the temperature of the court? That there are matters which are there, parted matters, criminal appeals being taken and all this. So, as an advocate, you have to be present 10 minutes earlier in the court. I don't have matter, why should I go? But that's not there. You have come to the court, sit in the courtroom. You have always a canteen 10 minutes before. You have always a canteen available during the recess, and after also court hours are there. But you must sit in the court and just watch as to what others are doing, because many cases are cited which I myself have benefited in our courts. Mr. Borulkar citing some cases, Mr. Sapkal citing some cases, and others citing some cases. And if the luck smiles on you, after 8 or 15 days you may have the same matter which was being argued by Mr. Borulkar or Mr. Sapkal in the court, where the judgment is cited and it is decided. All you have to do is draft it properly and tell the court, this is the point involved, this is the Supreme Court. Take for example, Section 17 of the Surface Act. Any person agreed by. So any person who has, even the person who has supplied goods to a surface company which is under the Surface Act, he can approach to the tribunal or DRT, whatever it may be. So that is how you have to do it. That then about another aspect which I also had a weakness in the case. When Mr. Borukar is appearing against me or Sapkal is arguing against me, previously I used to interrupt them. No, my lord, he is all telling lies. His client is all crook. He is all this. But as a time, as I developed, I thought that it's not good. Let him argue because it consumes more time. Then one day what happened was that I was sitting in the court and my another colleague was going to argue the matter. Now the judge knew both of us. I was for respondent, so he was about to begin. So the judge told me, Mr. Dhorde, small request, no chuna in the matter. Don't put, usko chuna mat lagao. That means interrupt him. So I told him, sir, I don't eat tobacco. No, but still you carry chuna. So that is what happens. But sometimes you have to be in a lighter mood in the court in order to be a good advocate. Here the other side, ultimately you know you can't win every matter and you can't lose every matter. Many times, as everybody says in the corridor, operation successful, patient dies. Very good matter, point decided of law, but petition dismissed. So this is what happens in the life. But then, of course, this thing they come with a practice in the court. I am not saying that the moment first day lawyer comes and then he learns all this. He comes and advocacy comes over a period of time. Now there may be some good lawyers, but if he is not a good advocate, it is of no use, because he will not be able to put his point across. Many times lawyers come with many cases, but when he start arguing, he doesn't know, no, my lord, take this, that lavor, then this. And if he is not a good advocate means he is not able to present his case properly. All that labor which has done last 3-4 days is wasted. I will tell you one case. In room number 46 in Bombay, our principal seat, one lawyer he subsequently became a High Court judge. One lawyer was arguing a matter. And that time it was second appeal. Those who have first appeal, second appeal was all reached when the property matters. So the lawyer was presenting a case, and it was about going to be 2 o'clock, some 10 minutes remained. The lawyer has brought junk of briefs, Lahore, then Oud, then this something from Calcutta, and he started citing one after another. The judge was irritated, he was against him. He said, second appeal, now what remains? Now he opened one book which was given by the lawyer, that authority, because that time there was no xeroxing. So one from the library and one for your own. And that was handed over to the judge. Now the honorable judge who was sitting there, he opened the brief. And one bug, bugs are not now there, no? All vanished. One bug came out of that book. Now the judge who was not very much interested in hearing that matter, he said, now this point is already. So the judge said to the lawyer, what this bug is doing in this book on the bench. He said, why you are unnecessarily trying to... But lawyer was very clever. He says, my lord, all the bugs have passed from bar to the benches. So sometimes there you have to take it in a lighter mood. Otherwise somebody will say, you have called me bug, what is this? So that is how you have to be little, or don't say anything. But lawyer who has given this answer to the judge who is saying that all the bugs have passed from bar to the benches. So that is how in some of the cases while practicing, if you have to be a good experience and years experience, you become a good advocate. Now, last but not the least, every case you have to be persistent. No, this I know, that I know. Every case you have to read earlier day. Otherwise, I have read it. What is the point? You don't know. When I was a junior, that matter, suppose cooperative societies matter, it lingered for 2-3 days as it was not reaching. My senior, we used to tell him at 8:30, sir, can we leave? He says, no, Justice Dharmadhikari, today I was sitting in the court, he has said some judgment has come. But yesterday we had all pointed out all the judgment. No, he was telling the judgment. So again find out another half an hour judgment. He will not leave you, and then but 9 o'clock he says, all right, now you can go. Persistence, till last moment you have to find out whether there is any new judgment, any amendment in the law or this. Then knowledge of the subject. Now I will tell you my experience over this Aurangabad matter about supply of water in the municipality. Fortunately, I am born in agriculturist family. So in 1952 we had a pipeline. So that cement pipeline and all that was going on. So since that day I have seen many pipelines. When this Aurangabad matter came to me after 1.5 years, so I called him one day, then he started telling me various phrases like this. That ULC, that wall, this one, non-written wall and all this. So I called him one day and I got all the drawings and learned from him. And then I told him, what are you talking about this? This is all a very simple logic. If the suddenly motor stops running, electricity is gone. If the water comes back, it should not go back to the motor and damage the motor. Therefore, there is a wall which is known as non-written wall. So, when you argue such matters, you have to have an experience and knowledge of that subject also. Now, engineering is not our subject like we do in medical jurisprudence. But reading with all the... So, when I was able to meet them and explain it to the court actually what is going on, and then I was able to get certain orders from the court saying that this is not permitted, that is not permitted, please help us. So, when you get such matters, you have to help, you have to study the subject. Pipeline is one subject which I learned many things, what type of iron it is, where it is, how the welding is done and all that. So, knowledge of the subject which you are going to argue, you must have enough depth to argue the matter. Otherwise, every time, what is this? The client is sitting there, engineer, what is this? It should not happen in your life. Now another important aspect is PIL. Now this Jalgaon Road and that Aurangabad Jalgaon Road PIL. So client came to me and he said, the court told him, we will put you in jail. So he gave a letter to the minister that I don't want this work. Then he came to me. Minister threatened him, no, you have to complete this work. Then I gave him 2 days and I got everything explained from him. So he said, sir, we have already, what happened? There was a 2-lane road. And that contract was given to him, drawing everything done. He dug the road and was about to put the road in its place, concretization. Suddenly, the MP from this place went there to Mr. Gadkari and said, sir, what is this happening? Why 2-lane road? We want 4-lane road. All right. Now they belong to same party. All right, 4-lane road. He came here and declared 4-lane road from Aurangabad to Sillod. Now that drawing, which was done for six months, and 2-lane road was prepared with the shoulder, that is gone. Another survey. Then it took another 8 months. Then they said the shoulders of the roads are very narrow. National highway standards are this. You will require acquisition of land. Now by the time this could 8 months survey is over, and then Mr. Gadkari said, forget it, we'll do compromise national highway. So that place in between the highway, that 6 or 7 meters late is left in there. By the time this is completed, their demand from Jalgaon came. Why only to Aurangabad and Sillod? We also want 4-lane road to be completed from Sillod to Aurangabad. Again survey. And it took only, that road was already dug up. It took another 8 months. So 2 years went in only doing drawings. And then thereafter, then I told him what is this shoulder and all this, now niceties, small thing I learned. And then I drafted a detailed affidavit and told the court, give me only 10 minutes. And I pointed out all these things. Otherwise, every time they will tell to the contractor, we will put you in jail. So he said, what I have done? And I told the court other thing also, sir, there is one very important VIP staying on that road. And he is demanding something from me, unwarranted demands. And he says, otherwise I will not allow you to construct the road. So court told me, tell me his name. So I say, I can't tell you his name. But he is a very important person on that road. And that is how the court passed an order, injunction not to interfere, and that road is fortunately now completed. My suggestion to you is only this. Then when you take up such matters, you have to study something beyond law. Concrete, cement, the shoulder of the road, the width of the road, the depth and all these things. So nowadays, along with that, along with only knowledge of law, you have to learn this also in order, because now all this PIL do on what? Very rarely it is decided on law. It is decided only on each case on facts. And if you want to know facts, you must know the knowledge of that subject. Unless you know what is pipeline and what is road, you will not be able. So you have to study that also. So in order to be a good advocate, you have to spare some time and do some engineering. Now tell me, with all these years, how many people, when you open the medical jurisprudence book, are able to distinguish between hanging and what is it? Suicide and strangulation. What is the distinction? Can you tell me today? All table is prepared. All same similarities here and there symptom. And it is ultimately in the each matters with surrounding circumstances. Now that is good, but how many of us are able to tell that whether this was a suicide or whether it was a strangulation? Now just even today you go home and read that Modi's jurisprudence. I think hardly there is any distinction on both the sides. Now another important aspect is this. There are good cases and there are bad cases. Good cases, you know what is going to happen in this matter. You know when the judge is sitting for a couple of weeks, you know in what cases he is likely to grant bail and in what cases he is not likely to grant bail. You know quashing matters, 498, mother-in-law, sister-in-law, you make all the parties. And then you go to the court, and when the court tells you, you say, all right, sir, I will not press for it. This is a good way of getting the case out of the hand. And after some time you can again come back. So one more case to you. And also you can save that person after the charge sheet comes. So these are the ways of overcoming the difficulty. Otherwise you say, no, that is very important person. He is the head of the family, and now if I don't press for his quashing or bail, what will happen to me? So this is all thing which we have to do is, all strategies and techniques we have to adopt in the advocacy. Friends, I think it is enough for the day, and I am thankful to all of you for hearing me patiently. I hope all of you become a very good and successful advocate in the life, and prosperous advocate in life. Thanking you. Thank you very much.
Thank you, sir, for your valuable expression on the views of today's topic, Art of Advocacy. Thank you for your valuable guidance, sir. Now we reach to conclude the program. I call upon Mr. Pathade, Library Secretary, to deliver the vote of thanks.
आदरणीय व्यासपीठावर उपस्थित सर्व मान्यवर, त्याचप्रमाणे या सभागृहात उपस्थित असलेले सर्व ज्येष्ठ विधिज्ञ, वकील मित्र मैत्रिणी आणि महाविद्यालयातून आलेले सर्व विद्यार्थी मित्र आणि मैत्रिणींनो, आजच्या या लेक्चर सिरीजच्या 4थ्या सत्रासाठी या ठिकाणी उपस्थित असलेले आणि आपल्याला अतिशय चांगल्या प्रकारे मार्गदर्शन केलेले ज्येष्ठ विधिज्ञ आणि आदरणीय धोरडे साहेब यांनी वेळात वेळ काढून आपल्याला मार्गदर्शन केलं, त्याबद्दल मी त्यांचे वकील संघाच्या वतीने आभार व्यक्त करतो. त्याप्रमाणे या ठिकाणी सर्व पत्रकार बंधू त्यांचेसुद्धा मी आभार व्यक्त करतो. आणि सर्व या ठिकाणी उपस्थित असे आपण सर्व वकील मित्र आणि मैत्रिणींनो, आपण वेळात वेळ काढून या कार्यक्रमासाठी उपस्थित राहिलात त्याबद्दल आपणा सर्वांचे आभार व्यक्त करतो. आणि हा कार्यक्रम संपला असे अध्यक्षांच्या वतीने जाहीर करतो. त्याचप्रमाणे बाहेर चहा ठेवलेला आहे, सर्वांना विनंती आहे की चहा घेऊन मग जावे. थँक्यू.